Now let's look at patents. Now, patent has to do with inventions. Okay, maybe inventions, works invented, or maybe works that has been invented but remodeled. Okay, so whether a new invented work or a reinvented work. Okay, more of that is what patents has to do with. Okay, patent it is on that those kind of creative work. That means an invented work or a reinvented work. Okay, now the steps to also follow to doing this registration, which means to determine the patentability, and then file specifications and claims with the registry, and then examination and possible grants, and then maintain annually with renewable fees. Now, this process is just a concise process, but also part of also what it entails is that it also has to go through opposition too. So if anybody opposes, oh no, I have a patent on this similar to what you want to patent, then it will not fly. Okay. Now, one thing I want you to know about these three: the copyright, the patent, and the trademark. Trademark is a registration that has to do with a certain kind of mark you're trying to own, maybe a certain kind of maybe a name or something, slogan. All of these kind of marks, the general word I would use for it is mark. Okay, you're trying to own, then you use trademark. But when it comes to copyright is something that you have published. Okay, you want to own. Patent is something that you have invented or reinvented. That means you remodeled. You want to own. Are you seeing the difference? So they have their own rules. They have their own way of ownership, and they also have what each and every one of them entails. So if you think about that work that you have that you want to safeguard, you want to also promote. Now, is it a trademark or is it a patent or is it copyright? But knowing these three, you see, the difference between these three is very important, like I have explained. Now, of course, the ownership in patents, it goes as far as 20 years, after filing, from the filing date, and then renewable afterwards.